We never really discussed what a quorum is, but I think we've got one for this morning. So let me wish everyone a good morning and welcome to the working group 4 of the task force. And this morning we've got several guests, 3 guests who have joined us, and we look forward to their presentations. I thought I saw Jennifer Simmons on the gallery. There she goes. She's joining us from North Carolina Access to Justice Commission. And we've had several conversations about fines and fees. And last week, we had a tremendous presentation from Dr. Crozier on DWI and failure to appear and what are often silent impacts on the population with tremendous impact for racial equity in the criminal justice system. But since they're not what many people consider bread and butter criminal justice issues, they often go unattended. And often the ability of citizens to navigate those penalties and punishments are difficult. And Ms. Simmons is going to help us understand how we can better citizens' ability to navigate those systems. Susan Pollitt and Luke Woolard are here from Disability Rights. We've only recently learned about the impact of restrictive housing, or what most of us call solitary confinement, and how that form of punishment is in fact in most international forums seen as torture, but it's regularly used in North Carolina. And when we talk about the impact of racial disparities in the community and how that affects North Carolinians and their view of the fairness of the system, what happens in the dark, and prisons are, for the most part, in the dark, out of public view, but they do have a very real world impact on the views of the fairness of the system. And we look forward to Ms. Pollitt and Mr. Woolard's presentations. Let me first, before going on to the final remark that I'd like to make this morning before getting to the agenda, ask if everyone received the minutes from last week's presentations. You recall last week we had presentations from Dr. Crozier from the Duke Institute for Science and Law, and from Gretchen Engel from the Center for Death Penalty Litigation. First of all, did people have a chance to review and see the minutes? I think that's a yes. If that's so, we'll ask if there's a motion. Going once, going twice, I'll entertain. There we go.
I had to unmute first, sorry.
So there is a motion to adopt and accept those minutes, and there's a second. All in favor? Aye. All opposed?
3:30. If they
Well,
get
okay.
earlier stuff, could they come earlier? It'd be like 11:30 or something.
I don't think that's a dissenting voice. So the minutes are approved. Thank you. I don't know, Justice Earls, good morning. A.G. Stein, good morning. If you've got a word of welcome, I think the working group is, let me just speak for the chair, is feeling the weight of these many meetings and the challenging work that we've taken upon ourselves as a working group. Not to say I'm getting fatigued, but it is wearying, and it's so good to have the co-chairs here to help spur us on. Having a chance to look at the agenda ahead of the working group, there's still a lot of work ahead of us, and we're looking now at the the next presentation to the task force of October 9th, and the final presentations to the governor are not that long away. As I read the calendar, December 1st and October 1st are just separated, I don't know, not by that many days. I think most calendars would say it's under 2 months. I don't know. But the pressure is on. And thank you to the working group for all of the tremendous effort and concentration you brought to the task. Mercedes, I know you're not with us visually, but we're glad to have Jennifer Simmons present to us. Did you want to say a word of introduction for Ms. Simmons?
Very briefly, Jennifer Simmons, what could I say? Jennifer Simmons and I first met when we were at a training, I think in like Omaha, Nebraska, or somewhere in the middle of the country, doing Social Security benefits training for the work that we both did in our previous lives prior to what we're doing now. And now she is joining us as, I believe, this attorney with the North Carolina Access to Equal Justice Commission, if I got that right. And we're super glad to have her because she's a wealth of knowledge. So thank you so much for joining us. And Jennifer, you can share your screen and take it away.
Okay, I am happy to do so. If that's the time we're at, let me then. I just gave a conference last week where I gave people a lot of advice about how best to share their screen. We'll see if I actually learned the lessons that I imparted at that time. I didn't learn how to hit F5 from, sorry for the close-up of my face as I try to get my screen. All right, can you see the slides now?
Perfect.
Wonderful, thank you so much. Well, I wanted to thank you guys so much for inviting me. Specifically, thank you, Mary, for the recommendation to include the commission in this important work that you all are doing. We certainly do understand that the issues you are considering are numerous, maybe voluminous is a better word, and obviously incredibly important. So again, thank you for allowing us to be part of that. My name is Jennifer Simmons. I'm a senior project manager at the Equal Access to Justice Commission. And what we'll be talking to you about today is our driver's license restoration project. And I also am going to share a little bit about the guide and file system that the Administrative Office of the Courts has just launched. I have been informed I have 10 minutes to make this presentation, so apologies for my fast talking in advance, but I've got a lot to cover. I can also see that my dog has made her presence in our background. My apologies for that as well. I hope y'all can, that won't be too distracting. All right, let me dive right in. I think the main import here is just to let you all know information that I'm sure you're already aware of, which is that there are many, many, many North Carolinians who are facing active driver's license suspicions based on their failure to pay traffic fines and court costs and failure to appear. As much as 15% of all adult drivers in the state of North Carolina are impacted by license suspensions, which is obviously not ideal for them or for our state as a general whole. Based on data from the Administrative Office of the Courts, when a traffic court debt is not paid within a year, it is not likely to ever be paid. Despite that, the average length of a license suspension for failure to pay is more than 8.5 years. And the second lesson I want you all to walk away with is that the large number of the failure to pay license suspensions are based on an inability to pay, not a willful refusal to actually pay. As you all know, the poverty rate here in North Carolina is extremely high. We're the 15th highest poverty rate in the United States. So folks simply cannot afford to pay, and license suspensions simply exacerbate poverty within our state. I believe you all have seen this slide before, which talks about how our court costs have risen at an absolutely astronomical rate here within the state. It raises a question of philosophy. Why are we actually charging the fines that we do? is a matter of philosophy. What is the purpose of the fines and fees that are charged by our court system? Is it punishment? Is it actually to fund the court system that the criminal defendants in these cases are involuntary users of? The facts show that perhaps it's not actually funding the court system. These fines and fees go primarily to county level government, to city level government, or to the state's general fund. It is only a small fraction of those fines and fees that are actually reallocated to fund the court system itself. So if the purpose is punishment, then you have to think about the question of proportionality and whether some of the relatively minor offenses that these folks are charged with really merit, you know, that 8.5-year average license suspension. I wanted to turn to the reports that the AOC is required to produce. These are judge by judge and jurisdiction by jurisdiction level reports on how many fees and fines are waived. Based on the current statutory drafting, there is no actual limit on the ability to waive fees, but this produces sort of an implicit pressure not to waive fees. Because judges believe that they are going to be either singled out for treatment politically, since judges are elected, or is a matter of pressure because they may actually have to face any ramifications. The AOC has actually, both the AOC and the School of Government have issued guidance that there will not be any actual steps, punishment otherwise, for judges that are in fact waiving fees, but these reports that are required by the General Assembly create at least the possibility of future ramifications, or if nothing else, that internal pressure that I was referring to. And then I wanted to just spell out a hair more the high cost of a loss of a license. Obviously, the inability to drive legally doesn't necessarily mean the inability to drive in many cases, but it can. And there are certainly people who genuinely stop driving, or at least try to limit their driving to only emergency situations once they have a suspended license. So that means they may lose employment that is not on public transportation lines. Transportation costs go up. Commute times, obviously, based on our public transportation system within our state, where it exists even, it are limited. Medical services, if you can't see a provider that's not on a bus line, again, if a bus line even exists, that is a huge limitation. Then of course you may be brought back into court because you continued to drive. So our data in our state is imperfect, but we do know that catastrophic racial disparities result in households of colors are disproportionately exposed to and severely impacted by traffic debt. Long-term suspensions disproportionately impact people of color. We invite you to view our story map project, which is highlighted here. You all will get a PDF of this to see more about the county by county correlation between poverty and race and suspensions. So I wanted to highlight a few recommendations. This may be too small for you all to read, depending what your screens look like at home. So if you'll bear with me as I actually just read these to you. Our first recommendation that we would propose is to abolish or greatly curtail the practice of suspending driver's licenses for unpaid fines and fees. There is a draft bill that was introduced in the 2019 legislative session, which would automatically restore licenses suspended for failure to pay after 12 months. That would largely address the issue as we understand it, not just going into the future, but actually all licenses that are currently suspended. Therefore, undoing the need for a project that we currently spend a lot of time on, as a matter of fact, a full staff person, which is mass relief on a jurisdiction by jurisdiction level. If this bill were to pass, that would no longer be needed. And as much as you hate to write someone out of a job, this is a job we would gladly exchange for this legislative fix. Our second proposal is to encourage DAs to utilize that mass debt relief for low-level traffic offenses through the driver's license restoration project or other efforts. We would frame that as an alternate. If that statute does not pass, this would be a solution to resolve driver's license, but it is subject to individual DA discretion, which, as we've seen across the state, results in an enormous disparity on a county by county level in terms of what relief may come for folks who have a suspended license. We would propose that we reform 7A-304 to require judges to conduct an ability to pay analysis before assigning costs and fines. At this point, waiver or reduction is not limited, but there's no requirement to consider ability to pay. And so that would be a substantive change that would make an enormous difference. And then finally, we propose conducting comprehensive trainings for judges and magistrates to encourage the waiver of costs and fines when appropriate. We believe that educating judges and magistrates about 4 things would be very impactful. 1, their ability to waive costs and fines pursuant to 7A-304, and that is as it's written now without a necessary amendment. The significance of waiving fines and fees for defendants who are financially unable to pay. The availability of a new AOC form, which is CR-415, I'll show you in just a moment, a motion for relief for monetary obligations for waivers and remittance. And 4th, that use of the order provided in AOC form CR-415 meets the requirements in 7A-304 that judges and magistrates have a written order supported by findings of fact and conclusions of law in order to waive costs and fines. So let me just show you very briefly, this is just page 1, the top of page 1 of this new motion for relief from fines, fees, and other monetary obligations. It is relatively hot off the press. It's maybe a month old out of the AOC at this point, but it's a new form which allows a petitioner, whether it's a litigant, whether it's a pro bono attorney, whether it's a PD, or otherwise, to petition the court to either waive fines and fees at the time that a conviction and sentencing is occurring, or to petition for remittance, that is reduction of fees that are already, reduction or forgiveness even of fees that are already existing. And this is a 4-page form. I haven't copied all of them, but I do commend that to your review if you have not already done so, because I think it's very well done and provides a new vehicle for relief. And sometimes the form is as important as the actual statute. I want to transition in the most brief way to a new opportunity that exists through the court system. This is a new program from the AOC. It's a technological innovation where users answer simple questions to generate court documents which are designed to accomplish a legal goal. The current case types are highlighted here in red on the right side of the screen. You may notice that these are all focused on civil case outcomes at this time. However, the branch does intend to expand these offerings to include an interview to generate expunction petitions, not the subject of my presentation today, but obviously a very important form of relief, as well as the motion for relief from monetary obligations that we just included. So this is a way that both self-represented litigants, as well as pro bono attorneys or other practicing counsel, can answer simple questions to fill out the form in a way that is legally accurate and effective, so that those motions can be generated more efficiently and by litigants who may need them, or again, pro bono counsel who may not have that expertise otherwise. We believe that is a very important innovation to expanding the number of these sorts of petitions that are filed, whether there's this kind of ongoing training or not. That was a very rushed job. I'm still not sure I kept it into 10 minutes, but I understand there's a few moments for questions. And so I certainly welcome anything you all may think is worth discussing more.
Well, thank you, Jennifer, for trying to collapse all of that important information into 10 minutes. And you were quite successful.
Thank you kindly.
Yeah, I'm struck by almost every screen that you showed. And perhaps starting with the 8.5-year average length of suspensions. That has to be a crippling effect, has to have a crippling effect on people sort of trapped in that situation. And it certainly prioritizes this issue for us. So thank you so much for that. The AOC form that you identified, is that something that the clerk of court would make available to the public, or does the issuance of that form vary from county to county, or is there some training that the AOC provides?
It is so new that I do not know of any training that's occurred on it yet. It should be available either in a county office, although I will confess to you, it's been longer than I care to admit since I've entered a clerk of court's office, certainly since March, and a bit before that too. It is available at nccourts.gov. I think public promotion of that form's availability has not gone, or has not been a high priority yet, perhaps. We haven't found the champion of this form to really promote it in a way that could make an impact. I do know it's making the rounds. There are grassroots efforts from the North Carolina Justice Center, as well as others who were instrumental in helping to get this form created and then to promote its use around the state. But there certainly is room for increased promotion. And I do believe this guide and file system will allow that to be done efficiently. The promotion can happen otherwise, but actually the completion of the form can happen quite efficiently once that interview is created, which I believe, and I shouldn't be speaking on behalf of the branch, but there's hope that it may be done before the conclusion of 2020.
I'll ask if other members have questions or observations to share with Ms. Simmons.
At the form that Jamie Markham would have shared with us. Same one.
Same form.
We certainly worked with Professor Markham on creating it.
Okay, thank you.
Judge Thornburg, do you know if in Buncombe County that form is available to the public, whether the clerk of court or some other court entity actually distributes that to unrepresented individuals?
As far as I know, the answer would be no, as far as I'm aware. But we need to work on that. Professor Markham put out a great guide outlining costs, fines, fees, and which ones were able to be remitted and waived and which one required notice. And it's a very detailed, I think, 4-page, thick paper for us to a bench card kind of thing. And so we use that. But in terms of something that would be available to the public and to attorneys and pro bono assistants, not that I'm aware of, but that's something that probably should happen.
And I think I'm recalling that in Mecklenburg County, there was like a self-service center that the clerk operates that distributes and make available forms, I guess, like this, with relatively simple, straightforward instructions that citizens who are unrepresented can take advantage of. And it would seem like this motion to remit fines and fees would be ideally suited for that kind of wide distribution.
I would say that the attorneys, and we have an active defense bar here, and they are aware of the possibility. So I've been the only judge doing criminal court for a while. We've sort of divided things up. And so when you have that kind of uniformity and the attorneys become aware of the possibilities and you sort of understand what the situation, the financial situation of the defendants, you have sort of an understanding, and the attorneys are getting much better at it, but we need to have greater education, because obviously you will have defendants who are represented by folks that are not aware of the possibilities, and there may be a financial situation or a specific fine or fee that needs to be brought to the attention of the court. So greater education is necessary.
Yes. Mike, did I see your hand?
Yeah, Henderson, can I ask Jennifer a question? And it's a basic, maybe a dumb question, but you mentioned at the beginning of the presentation that if the fines aren't paid within a year, the chances are they'll never be paid. So what happens to those people? Do they just not have their driver's license for the rest of their life?
Yes, until there's some sort of administrative relief. Right now, we are working on mass relief to work with DAs on a county by county, or rather district by district level, to go in and actually move for remittance of those outstanding or long outstanding fines and fees based on failure to pay. There's also failure to appear, which is a block for some license or suspensions of licenses as well. That we're not currently addressing. But that county by county level, we've had 5 counties where we've moved for that relief. We've been able to provide relief for about 50,000 North Carolinians. There are about 250,000 though that are still outstanding that, you know, again, this has been over a year. So we're talking, what would that be, 5 more years to get that taken care of? There certainly has to be a way to deal with it much more efficiently than this county by county level relief that we're providing through the mass relief efforts that our Pro Bono Resource Center is currently providing.
And if I could just comment to that, and you alluded to it in your presentation, if you live in a rural county like where I live, there is no public transportation. You know, to get to work, to just live your daily life without transportation is almost undoable.
Mike, as a practical matter, I know from the years that I had more contact as a public defender, that the impact is it drives people underground, and it leads to all sorts of unhealthy activities and unsafe activities on the road in terms of selection of who's able to drive under certain situations. It impacts employment, obviously, and access to other necessary social services. So there are all sorts of consequences that are not sort of seen as straight line consequences, but they have real world impact on communities. And the notion that this lasts for an average of 8 years is just shocking to me.
If I may, Henderson, thank you on that point. I'm very proud of our story maps, and I wish to goodness I had more time. I told my executive director I could have given 15 minutes just going through our story maps and how they demonstrate that statistical impact. And I will circulate that URL, if it's all right, through Mercedes, which I've already sent her these slides, and the bill that I referenced, that draft bill from 2019. And I know you all are enormously swamped, but I am very proud of those story maps. And I think they help tell that story in a very impactful way that you all might find helpful if this is an issue you're interested in talking about more.
Thank you for that. And Jennifer, as you can see, our time at the working group sessions are so constricted that to the extent you can send that link to Mercedes and we can make it a part of the working group record, that'd be enormously helpful. Also, sort of continuing the work of the working group often happens offline. So I think your recommendations identify certain concrete steps that we could put forward. And I think myself and Mercedes would like to stay in touch with you as we shape up potential recommendations to take to the task force. And thank you again for being available.
Listen, can I ask her one question?
Judge Thornburg, yes, sir.
Jennifer, often when this issue comes up, those that are skeptical, I guess you might say, that their point is, well, this increases collections. Is that true? Have you looked at other jurisdictions that have made these changes, and does it make any difference?
Yes, there are both nationwide studies as well as the data that we've been able to analyze using the AOC data from North Carolina shows that drop off after the 1 year payment period is truly shocking. It is a very minimal amount of the current revenue is generated from fines and fees after 1 year. Essentially, if people are able to take care of it, they take care of it within the first year.
Thank you. That's helpful.
Thank you, Judge Thornburg. And thank you. It's been an honor and a privilege to participate today. I really appreciate the opportunity to talk to y'all.
Thank you, Jennifer. And please, if your schedule permits, please stay around for the rest of the working group session. We're looking forward to hearing from Susan Pollitt and Luke Woolard on the impacts of restrictive housing. And Susan, I'll tell you up front that I got a question from a task force member that's not a part of working group 4. But the question had to do with the availability of the law libraries within the prison system. And the suggestion was that there was a racially disparate impact with the removal of those law libraries from the system. And I know this isn't what we've asked you to talk about, but if before the end of your presentation or appearance here, you have any thoughts on that issue, and if you're willing to share those thoughts with the group, that would be helpful. But not to stop you and Luke from your main item of discussion, we're anxious to hear about the policy involving restrictive housing in the prison systems, and how that shapes and affects both the reality of racial equity and the appearance of fairness in the system. So we look forward to your presentation, Susan and Luke. Thank you.
All right, and I'm gonna go ahead and try and share my screen. We'll see if I'm as successful here.
There you go.
Okay, great.
So my name is Susan Pollitt. I'm an attorney with Disability Rights North Carolina. And I'd like to tell you a little bit about disability rights because we're a unique organization in the state and across the country. We are what's called the Protection and Advocacy System for People with Disabilities, or the P&A. This is part of a nationwide system created by Congress in the 1970s to protect and advocate for the rights of people with disabilities when they identified that state protection systems were uneven and inadequate in many cases to do that job. So Congress also gave us a toolbox, a unique toolbox to accomplish our goals, and that includes access to people, places, and records, including prisons and jails. So through our federal authority, employees of Disability Rights North Carolina can access prisons and jails anywhere where people live and operate who are receiving services. So Luke and I and other members of our staff have been into restrictive housing cell blocks and talked to people through the doors who are living and receiving services there. And that has pulled back the curtain a little bit that Mr. Hill referenced, that prisons are dark places that generally other people don't know what's going on. And so we've had the privilege and the honor and the responsibility to go in there, and we're very pleased today to report to you some of what we've observed and found. Some of it keeps me up at night, frankly. So our work in the prison system has been going on since 2011. It's mostly been in coalition with other mental health advocacy groups. It started with Governor Perdue on the occasion of a person who died from lithium toxicity, as well as a public report of an internal audit of the old Central Prison Mental Health Services, where there was gruesome conditions of blood and lack of records, and something that you hope would not reach the public, or would not exist to reach the public. And so it was a point in time when Governor Perdue realized that it was appropriate for there to be coalition with advocacy groups. And so we've been working since 2011 in that capacity. Next slide, I guess. So restrictive housing is harmful, and it's recognized not only nationally, but internationally. Restrictive housing is solitary confinement. It goes by many different names in many different states and countries, but it's no doubt, no debate that it causes serious harm. It's toxic to brain functioning. It causes panic attacks, paranoia, distortions, and problems with impulse control. Sadly, a study right here of North Carolina prisoners conducted by professionals at UNC Medical School and the School of Public Health identified that serving time in solitary confinement actually it can be deadly upon release. That more people who have served time in solitary confinement die within the first year after release from solitary confinement, either from suicide or homicide or drug overdose, and that this study confirmed what we know and what DPS knows, that many people with mental illness and other disabilities are the people who are placed in solitary confinement in North Carolina. There's also support from the courts across the country for this. There are many court decisions that have ordered some amount of relief, often to the specialty populations, women, pregnant people, youth, or people with disabilities, because there's a recognized objective risk of psychological and emotional harm when people are placed in solitary confinement. In North Carolina, our conditions of solitary confinement are harsh compared to other states. It's 22 to 24 hours a day in a small locked cell. Long-term solitary confinement is generally agreed across the country to be 15 days or more in these conditions. You eat in your cell, receiving your tray through the trap in the door, which we have pictures of, and Luke will be showing you soon. The policies require that you be offered 1 hour a day of exercise 5 days a week, but that can be not offered if the conditions in the unit don't allow it, or the correctional officers are very busy. Oftentimes people refuse that because to get that exercise, you have to be shackled in 5 different ways to exit your cell. And often you go into another cell where people can watch you, and it's you can't be shackled even inside that exercise cell. Sometimes you get showers 3 times a week for 10 hours. Again, it's an exercise of shackling. To go to the showers, the correctional officer can decide that you need to be showered in shackles, which is not a simple thing to do. There's no TV. Visitation is limited. Phone calls are limited. Your property is limited. These are harsh start conditions of confinement. The Vera Institute of Justice provided technical assistance to North Carolina from 2015 to 2016 regarding how to reduce the use of solitary confinement. And according to their reports, there are different categories of solitary confinement that differ in small respects, except HCON. HCON differs in a big respect. It's something built on the campus of Polk Youth Center in Butner to replicate the federal maximum security unit in Colorado. That's notorious to some degree. So this is a place where there's no contact. It's built so that people never leave their cell. They don't go to a shower to shower. The shower is in their cell. They don't leave to exercise. They exercise in a concrete space right outside their cell door. So HCON is unique and the most restrictive. The other kinds of solitary confinement are restrictive housing for disciplinary purposes, which is when you serve a sentence for a rule infraction. Could be 30 days in solitary confinement for the rule infraction or more. Restrictive housing for administrative purposes could be for any reason. It's by policy meant to be a shorter amount of time, but if you're a new admission to prison and they're not sure about you, they can place you in administrative segregation. If there's been a fight and they want to sort it out while they investigate, they can put you in administrative segregation. If the officer in charge is worried, they can put you in administrative segregation. So this is very discretionary. Control purposes is something that we want to talk to you about more, because this is an indeterminate sentence to restrictive housing, to solitary confinement, not based on a rule violation or the due process procedures that our Supreme Court and other courts have imposed around the assignment to solitary confinement for a disciplinary violation. So restrictive housing for control is very concerning and intersects with the overuse of solitary confinement on people who are Black and of color in North Carolina. There's protective, if a person is determined by the prison system to not be safe in the general population, they can be placed in restrictive housing for protective control. And then there's a modified housing, which is a step down or a step up sometimes to restrictive housing, but it's very restrictive itself. In some cases, people are in their cell 22 hours a day. And that's why Vera identified it and considered it to also be restrictive housing or solitary confinement in North Carolina. Next slide. When it's used as punishment, this goes over some of what I was saying, but in restrictive housing for control, a person is assigned there through some reviews by prison administrators, the facility custody classification committee or the director's custody classification committee. And it's for 6 months, generally. You're there for 6 months, you don't get reviewed. It can be renewed for 6 more months at the end of it, whether you commit a rule infraction or not while you're in there. There's no promise that if you behave in a certain way, you will not be confined in restrictive housing again for another 6 months. And this can be renewed and renewed for years, and has been in North Carolina. So this creates a loss of hope for people. Of the 6 people that have committed suicide in our prison system this year, 2020, half of them were in solitary confinement when they took their lives. So it's, next slide. And this just goes over what I said before, and I don't know if we're running on time or not, but I'll just go to the next slide because that sort of repeats. And Luke is going to bring you this information.
Hi, so I am going to be presenting on the discipline system, and by that I mean just the system through which folks are accused of infractions, found guilty of infractions, and then punished for those infractions. And I wanted to start off with this because there are several aspects of the disciplinary procedures that make it susceptible to implicit bias. I believe I saw that the committee has been sort of educated on what implicit bias is, but again, it's just the, I guess, unconscious stereotypes that sort of everyone has, and they're particularly damaging when it comes to race, especially considering that folks who are incarcerated when they're accused of an infraction do not have near the same due process rights that somebody on the outside would have. There's less chance for them to use proper procedures to combat the implicit bias. And really the fact that at least for restrictive housing for control and HCON, somebody can be put in there or kept in there based on staff perceptions of their dangerousness. That's an issue because both because of implicit bias and because the more infractions people tend to get, the more dangerous staff tend to think that they are. There are multiple studies stating that folks' implicit bias does sometimes lead them to judge people of color as more dangerous than their white counterparts. And we've seen probably the most surprising and what really put this on our radar is that we began in mid-2019 to track the weekly data put out on DPS's website regarding just basic information about who is in restrictive housing and at what level. And we saw that as the custody levels increase, so as we get into the more and more restrictive housing units, ending with HCON at the top, the proportion of people of color who are incarcerated at those levels increases. And you will see that. So here, this top section, you'll see the percentage of folks. These are averages from the data we took from July to December in 2019, and the approximate ratios. So you'll see, if we can start down here, the North Carolina population at baseline, and that's for folks who are not incarcerated. That's everyone in the state. 69% white, 31% people of color, 21% Black. And you have the total active population. That's the population of incarcerated folks in DPS. Tends to be 35% white, 65% people of color, and 51% Black. Now, you see those ratios a little bit reflected when we're looking at restrictive housing for disciplinary purposes, restrictive housing for administrative purposes. It's sort of, it differs a little bit, but approximately the same, where you really start to see these proportions of people of color and Black people who are incarcerated is when we get into restrictive housing for control purposes and HCON, the two places where folks can be kept, based only on their perceived dangerousness, not based off of any sort of violation. We are seeing sort of the same thing play out here as of July of this year. This is just a snapshot from one particular week. And we see that that trend of the upward ratios as we get higher and higher in the custody levels is being maintained. These are some of our observations of restrictive housing. As Susie said, we have the opportunity to go into these units and talk to folks. We also regularly get letters from folks who are incarcerated in these units. So these are sort of just snapshots of what we're seeing. We are often seeing folks being kept in restrictive housing review after review. So they are turned down time after time, despite not having any new infractions. Often they'll just get a slip saying that, they were reviewed and they're being kept in. And like Susie said, that is just very disheartening to folks and doesn't give folks a lot of motivation to remain infraction free. We've recently heard of a few reports of people being maced while in the cell through the cell door. Rec time, as Susie pointed out, for some of these units occurs completely inside a small cage. It's indoors. Folks can be in restraints for rec. Some we've heard will just refuse recreation because of it's just a whole procedure to try and go through to get the shackles put on, get in your cell, come out, go back in. So some folks actually skip rec because of that. We've seen medical care, including psychiatric care, not adequately available in a lot of these units. And as we mentioned before, the Yale study found that a lot of folks are in these restrictive housing conditions for months and years, and that also comports with what we've heard on an individual basis from folks who are incarcerated in these units. So these are just some photos that we like to use to sort of really drive home what the conditions are, what it means to be in one of these cells. I believe this is the door 2 unit on HCON. These next 3 will be from Central Prison, I believe from Unit 1. Here you can see, I believe that is one of the cages, or if it's not, it is certainly indicative of one of the cages that folks are taken to exercise in for recreation. That is the standard looking door for restrictive housing cell. So as you can see, it's very limited light, very limited ways that folks can communicate. And like Susie said, even when we go visit, we're sort of trying to project ourselves through the cracks in the door to try and speak with these folks. It's another photo of a door on a restrictive cell. There's the inside. So as you can see, bed, toilet, all in very close proximity. Like we said, often these cells are the size of a parking space. And keeping in mind that folks are, except for shower time and rec time, doing all of their daily activities in this cell. So that includes eating their meals. So restrictive housing reform has occurred in several other states. It is not a way out there idea that cannot be done. Several states are taking steps towards this. Colorado banned the use of solitary confinement or restrictive housing for more than 15 days, as did those other states. The Colorado example is, I think, particularly salient to me because that was actually an effort that was led by their prison administration system. And it occurred after, I believe, one of their top prison officials actually spent, I believe, maybe 72 hours in solitary confinement himself in order to see what it really is like, and came out with a very changed idea of what they need to do to restrict the use of this type of housing. There have also been court orders in California, Texas, Wisconsin, Indiana, and multiple institutions and professional groups, really from corrections institutions to advocacy agencies, have all called for the abolition or restricted use of solitary confinement. Includes the US DOJ, the Bar Association, notably the American Correctional Association, Vera Institute, and the United Nations under the Mandela Rules as well. So I'd like to get a little bit more into just the, I can't call it an overview of the prison discipline process, but we did try and pinpoint areas that were potentially problematic or where that implicit bias might be able to show through. So infractions of any type are grouped into classes A, B, and C. Class A and B are the two types of infractions that you can get time in restrictive housing for. Class A, you can get up to 30 days. This does include the more serious crimes like assaults. It also includes lesser infraction like masturbation. I will say that the assaults, especially if they tend to lead to injuries, especially if those injuries are on staff, can also get you put on restrictive housing for control purposes or HCON. Class B is 20 days. This includes things like profane language and also something we see are sort of vague infractions, such as interfere with a staff member in the performance of their duty. And several of these sort of defined defined sort of infractions are open to interpretation, we'll say, by corrections officers and by the folks who are ultimately deciding if the person is guilty or not. Anyone can allege misconduct. Infractions can easily lead to long stays in restrictive housing, and that's beyond the maximums that they would do, say 30 days in restrictive housing for disciplinary. But if it was a serious assault, you might then go to another restrictive housing unit, and every infraction that someone is found guilty of will go on their record and then increases the likelihood that they could get put in restrictive housing, because more infractions tends to make somebody look like at least a more dangerous person. There are limited due process rights. We will get into that a little later. It makes the allegations very hard to fight, and it makes the few rights these folks do have very easily waivable. There is an appeals process. The appeals process can take up to 30 days, and during which the punishment may actually be carried out. If those are fees and fines, I mean, that's a little less serious, but if someone's put into restrictive housing during their appeal and you spend the 30 days in there anyway, might not quite matter to you very much how much that appeal turns out. You might want to get it off your record, but you've already done your 30 days. So here are the rights of some of the folks accused of infractions. They get 24-hour notice of a hearing. They can request that information is gathered and presented at hearing, things like asking other witnesses who might have been there, things like that. There's no requirement that the prison officials actually gather or present that evidence. They are given an opportunity to refute the evidence in person. And like we said, they have the right to appeal, but that can take up to 30 days and the person may be punished during that. One of the more troubling things we see is that a lot of the rights that these folks are given are waivable and can be waived either through failure to make a written request. The request that information and evidence be gathered on your behalf and presented. If you don't make that request in writing, it's considered waived. You can waive some requests by simply being what's called uncooperative. And that can be something sort of as inconsequential as failing to sign the appropriate forms or refusing to sign the forms. All right, and I believe Susie is gonna take it away and talk about some earlier progress.
Thank you, Luke. So I mentioned that we have been working in collaboration with others and with the Department of Public Safety over time to reduce the use of solitary confinement and increase the identification and treatment of people with disabilities. This has gone on through several administrations and significant progress was made at times. I would say that when the tragedies occurred in 2017 and 5 correctional staff lost their lives, this work came to a halt. We were meeting regularly every 2 months with leadership of the Department of Public Safety. Those meetings ended in 2018 and have not resumed yet. There's been leadership changes at the Department of Public Safety that have probably made a difference, but I'd like to quickly go over some of the progress that we made over time. Significantly, crisis intervention training was commenced in the North Carolina Department of Correction. And this is the same thing that's in the community, but it's used in the prison. Officers and all staff, medical staff, program staff are trained in de-escalation techniques. And the cross-training of the disciplines was a very positive factor for people who work in the Department of Correction. It was a unifying factor, it was successful. The DPS showed us examples of times when violence was avoided because people were using their de-escalation techniques that they were taught. It's our understanding that crisis intervention training is not a priority at this time. I don't believe it's going on. We brought in national consultants to review the number of people with mental illness in solitary confinement and their treatment or lack of it. That we are not at this time able to provide what is nationally identified as needed for somebody with mental illness in solitary confinement, which is 10 hours of out-of-cell therapeutic programming a week. They need to actually get out of the cell and not be technically in solitary confinement 22 hours a day in their cell. So we got that advice in 2012 and again in 2014 after Mr. Kerr died at Alexander Correctional Institution during a psychiatric fit while restrained. He died of dehydration after about 5 days in his cell, restrained. And that's what we're trying to avoid. We're trying to avoid those bad incidents that bring publicity and cost the state a lot of money in settlement. Advocates requested, and Commissioner Geis at the time applied for technical assistance from the Vera Institute of Justice on how to reduce the use of solitary confinement. And they studied our system for about a year and produced a 90-page report with many recommendations, a few of which we have adopted and many remain to be taken up. Thankfully, the General Assembly appropriated about $8 million of that $12 million for something called therapeutic diversion units, which are settings where people who have mental illness can go and receive therapy instead of being in solitary confinement. And the aim is to release them then to the general population. Right now, about half the therapeutic diversion beds are being used for COVID isolation. That's affecting everything. We know that, we understand that. But this is not enough. Even when fully operating, it's about 188 beds. And there are many more people with mental illness and other disabilities who need this therapeutic avenue out of control. So we have been disappointed that there hasn't been another appropriation since 2015 to increase the mental health services in the prison system. So the next slide. There was progress on professionalizing the services, psychological internship. UNC Psychiatry is providing excellent services when they can. There's a lot of telepsychiatry that's going on. A treatment mall was created inside Central Prison Mental Health, which replicates what's at Central Regional Hospital and Cherry Hospital, where people can leave their cell and take classes in anger management or, frankly, literacy is needed often. There's an art therapist who works at the treatment mall. So that's very successful, but you have to be in the regular population to attend that mall or get a special exception from your conditions of confinement. So people who are in control status and they need acute mental health services are actually kept locked in their cell in the mental health facility 22 hours a day and come out. We've urged 10 hours of therapeutic programming a week. Last I knew, they were up to between 4 and 5. So that's a job still to do. And then in 2015, in response to Mr. Kerr's death, there was an internal behavioral health task force led by Arthur Beeler. Some of you may know, he's a professor at Central. And it included a lot of academicians from our state, East Carolina, UNC, and they produced a long report with many recommendations. Again, it sort of got the file drawer treatment, unfortunately. So we've made.
Suzanne, I just want to say we have about 15 minutes left, and I want to make sure that we have enough time for questions and to discuss the rest of the agenda. So I just wanted to do a quick time check for you.
Thank you very much.
Yeah.
So I heard Justice Earle's talk the other week to the legal service community, and she said that the recommendations so far are ones that that are agreed upon and can be implemented without further study or cost and so forth. So we wanted to provide some recommendations like that to this committee. One thing would be to establish a committee to work with DPS, academia, the community, and advocacy groups to address the racial disparity in the use of restrictive housing for control status. This is a VERA recommendation to other states who have a similar demographic in their restrictive housing. I'd like to suggest that we end the solitary confinement of people who are under 21 through advocacy and Commissioner Geis's leadership. Frankly, in 2016, the solitary confinement of those younger than 18 was eliminated in North Carolina. But between 18 and 21, there's still a sizable group that are placed in solitary confinement and suffer this distress and lifelong trauma from the experience. Many states and other organizations have recommended that this curtain be pulled back a little bit more further on the use of solitary confinement, and that the prison system report either annually, biannually, more frequently to the governor and publish on their website the use of who's in solitary confinement, how long are they in solitary confinement, what are they in solitary confinement for. And on a later slide, we have a list of what we suggest be reported. And that is actually a list created by ALEC, the right-wing group, who believe that this is important to the humanity and to the successful re-entry of people into our community. So that's just getting at the lack of controversy regarding this recommendation. We'd like to urge the resumption of crisis intervention training, that the correctional officers on a control block receive special training, including CIT, but also an American Correctional Association correctional behavioral health certification, which is what Dr. Junker, the DPS head of health and wellness, is urging as well. Provide a step down, provide people who are placed in solitary confinement with information about what they can do to get out. So that there's some hope, something that's positive that they can work on while they're in solitary confinement. That people, again, this is a ACA recommendation, an ALEC recommendation that I'm coming to, that a multidisciplinary team review the offender every 30 days, not every 6 months, to see if they can progress out of solitary confinement. Create incentives. Right now, there are very few incentives, incentive system in our solitary confinement. I don't understand that. It's different from other state systems for simple rewards, such as an additional phone call home. And that we stop releasing people to the community directly from solitary confinement. This has been something we've been after for a long time. And again, this is an ALEC recommendation, as well as others, that offenders be released from solitary confinement 90 days before they're released to the community. The following slides detail those a little bit, and I think Luke can just flick through those some. I did want to stop at the 21 and under, because Luke added some statistics at the bottom. Right now, there are 125 people under 21 in restrictive housing. 83% of those are people of color and 76 are Black. These were statistics that he added yesterday. 21 of those 125 are in disciplinary segregation. So that means most of these are in that discretionary assignment to control status or possibly HCON. These are our longer term recommendations, which you can read when there's more time. Thank you very much for having us. I would comment that I do know a little bit about law libraries, because I was working at Prisoner Legal Services when Bounds versus Smith was decided, and the law libraries were eliminated in exchange for provision of people trained in the law, which was Prisoner Legal Services. Unfortunately, Prisoner Legal Services budget has since been cut from what Judge Fox ordered in the Eastern District when Bounds versus Smith was ongoing. And if you don't have other resources, Prisoner Legal Services doesn't have the resources to help everybody with post-conviction relief at this point, or civil civil rights litigation about the conditions of confinement. So there is an impact, I believe, in the loss of law libraries on people of color and Black people in our prison system that results in the worst violation possible, loss of liberty, extended confinement, perhaps with an unlawful or unfair conviction. Thank you.
Thank you, Susie. It was probably unfair for me to ask you
That's all right.
to comment on the law library. I think what you brought to us this morning was so, even in just the overview context, it was so overwhelming that, yeah, I think we should concentrate our attention on that presentation. And I would open up to the other committees if they've got questions or comments. Mary?
Thank you, Susie. That was that's really compelling, and I have two comments. One is, of course, that in addition to the torturous conditions and restrictive housing, the disparate use of any prison discipline leads to people spending more time in prison. You know, even if they don't end up locked down, they're losing the opportunity to earn game time toward their minimum sentence. The other thing is, I just wanted to correct something. Prisoner Legal Services just did sustain a significant budget cut in 2013, but we worked very hard. There are probably not enough resources to provide all the people who write in with conditions claims with representation. 100% of the people who write to Prisoner Legal Services with post-conviction issues have their cases reviewed and evaluated and have representation offered to them if the attorneys spot an issue. They get court documents, they get transcripts, they interview the attorneys. It's not perfect, and I'm sure they missed stuff, but we worked really hard to make that happen, and it's something that I'm kind of proud of after 11 years there. So they need more resources. They do a lot with what they have. I'm not there anymore, but everybody who writes in about their convictions gets a review. I'm sure stuff gets missed, but it's 100%.
Thank you, Mary. Sorry about that.
It's okay.
Well, thank you for that. Susie, you mentioned in your presentation that there was sort of uneven response to the issues of restrictive housing, but there were fits and starts in terms of conversations with the agency, with DPS. And you also noted that the tragedy in 2017 had a very negative impact. Yeah, there seems to be some patterns that we're seeing across the board. In the 2017 tragedy, as I understand it, the prison staffing was down 25%. And, you know, my conversations, individual with corrections employees, talk about the stress that arises from those sorts of staff insufficiencies. And well, that's a whole big issue. One of the recurring themes is that many of our institutions do not get the resources that they need. And I think in your presentation, the compromise between the $12 million project and the $8 million funding and the need to respond to the COVID emergency, I mean, it just sort of comes back to the issue of resources and the squeeze that puts justice professionals and administrators in. We appreciate first of all, let me pause. I know we only have a few minutes, but if there are comments or questions that members have, let's take advantage of even taking a few extra minutes for those questions or comments.
Luke or Susie, what are the numbers of the folks in restrictive housing? If you know.
If you give me just 1 minute, I can pull our most recent data. Just one.
While he does that, Henderson, I would, I like the point that you just made, and perhaps our working group in our recommendation could include in the package increased salaries and training and hiring criteria for corrections workers at the same time that we recommend some of the things that Susan has mentioned. I think they go together.
Judge, if I could comment briefly, I think that's really true, that when you have to do both of these on a parallel track. You have to provide a safer workplace for people who will want to come and work and stay in the Department of Correction. And to do that, you have to reduce some of the violence that occurs when people are treated this way and locked in cells and so forth. And that's been shown actually nationally, that their respective prison administrators that say solitary confinement is not necessary to a safe prison, that you can accomplish more goals without it. And I think that includes a safer workplace.
To the question about the actual numbers of folks in restrictive housing, as of July this year, the report that we pulled had about 2,631 folks in restrictive housing. I'm defining that only as the folks who are in restrictive RHCP, RHDP, RHAP, and HCON. So that doesn't even include the folks who are in protective or modified. I can easily, if the committee would like, pull the data from this most recent week and send that along with sort of a racial breakdown, but I can say those numbers and the numbers of folks in the various different units is looking about like what we saw pretty much all through 2019, with an exception that we're seeing in this year in recent weeks, a little bit of an uptick in the number of folks who are in HCON.
Thank you, Luke. And please do supplement your presentation with that additional information. And Luke and Susie, I think there's no way to overstate our gratitude for your bringing this information to us. And it's just a daunting amount of information. As a typical matter, we sort of refrain from making recommendations for a study commission or a committee. But we especially appreciate that your lead recommendation was to form a committee of DPS and other stakeholders to review some of these important issues. And it strikes me that if there's one area where that kind of recommendation to study and to collaborate is important, it's this one. So thank you for that recommendation and the other recommendations. And I'm sure staff of the working group, myself, hopefully Mary and others, will be in touch with you as we sort of think through what we can offer to the governor and to, first of all, to the task force in terms of recommendations that we can take on. But this has been an incredibly important presentation. I'll just give one last moment to see if there are any final comments or observations from members before thanking you finally and releasing you from your subpoena, you and Jennifer. Okay. Seeing now, you've got our tremendous gratitude. Thank you both, Susie and Luke. I think we've got a lot ahead of us. I think because of the lateness of the hour, I'll just mention that we've got efforts to include reports from Professor Frank Baumgartner, Mecklenburg County Sheriff Gary McFadden, both on death penalty related issues and Second Look Act issues next week. There's a balance or juggling that Mercedes and I will continue to work through in terms of how best to use the limited time ahead of us. We see ahead of us collateral consequences still on our radar, and of course some continuing presentations regarding death penalty. So there's an enormous amount of work ahead of us. Thank you for your patience and your diligence, and there will sure be follow-up on what Susan and Luke provided us this morning. Thank you all. Have a great week.